Now, welcome back. Now, we've got Minister-Designate Professor Firoz Cachalia, who will be sworn in later this morning as the Acting Minister of Police. And this, of course, follows the Constitutional Court's order dismissing former President Jacob Zuma and Umkhonto WeSizwe party's urgent application challenging President Cyril Ramaphosa's decision to place a Minister of Police, Senzo Mchunu, on special leave. Now, handing down the order yesterday, Justice Rammaka Mathopo said that the matter did not warrant the court's exclusive jurisdiction and that the applicants had failed to make a case for direct access. And joining us now to talk more about this matter, we joined virtually by Benedict Phiri, attorney and managing director at LusPrudentia Specialist Counsel. Benedict, always a pleasure having you. Welcome to Morning Live.
Good morning, Sakina. Thank you for the warm welcome and good morning to the viewers.
Now, if we could just dive straight in, because there's so much that I'd like to pick your brain on here. Did you expect the Constitutional Court to dismiss that application for direct access brought by Umkhonto WeSizwe party yesterday on an urgent basis, by the way?
Yes, I think that was a to be expected outcome because there are a few components that were in operation in that matter. One was the element of urgency, and we know that the Constitutional Court isn't necessarily, set up to be an urgent court, given the number of judges and the type of issues that it engages. Secondly, because of the relief that the MK party was seeking. The first was obviously setting aside or declaring the decision by the President to put Minister Senzo Mchunu on special leave as being unconstitutional. The second was to also say that the establishment of the Mathanga Commission, as we now know it, was also not in accordance with the Constitution. And thirdly was the appointment of Acting Minister Firoz Cachalia in that capacity. All of those issues did not necessarily result, given that there were powers that were undertaken by the President in the engagement of the Constitutional Court's exclusive jurisdiction or a matter for direct access in that particular instance. So I think that decision was to be expected, particularly in light of the arguments that the President made. I think it was very clear, or at least they were more persuasive than the MKP's arguments around that question of direct access and the jurisdiction of the Constitutional Court.
So that takes care of the jurisdiction of the Apex Court and, of course, that access for, or rather, the appeal for direct access. But what does this mean in terms of the actual merits of what the MKP were trying to argue, Benedict? Because where does this leave them now in that regard?
I think it's also important to point out that, some of the merits were ventilated during that hearing, even though the matter didn't turn on those. And I think that will give us an indication of what's likely to come, because what the MK party needs to do is, if they do intend to continue with this application, is approach a High Court. Obviously the swearing in of Prof Cachalia is happening today. Minister Senzo Mchunu is already on special leave, and the Mathanga Commission has already started its work. They already have appointed the evidence leaders, and they've indicated that they'll be meeting Jerome Konazi imminently. So by the time that this MK party application actually sees light of day in our High Court, I think the horse would have bolted on a number of fronts. And given that it will be starting at the High Court, and given the type of issues that are involved, I think we're likely to see if any one of the parties is successful at that level appeals all the way to the Constitutional Court as well. So in a way, this application is almost fizzled. It won't have the necessary impetus to actually result in the outcome that it was intended for, because by the time an actual decision is made, the horse would have long bolted. So in a way, what the MK party did was bringing this application urgently was a big gamble. They've lost that gamble, and it's almost muted any further challenges that could be effective through the court process going forward.
And that application, Benedict, also sought to challenge the President's establishment of a Judicial Commission of Inquiry into very serious allegations that were leveled against the Police Minister, Senzo Mchunu, by the KwaZulu-Natal Police Commissioner, Lieutenant General Nhlanhla Mkhwanazi. So, looking at that judgment yesterday, and do you believe that it actually reinforces President Cyril Ramaphosa, or just overall the presidential discretionary powers in terms of what the president can and cannot do?
I think, the judgment, makes it clear, and you would have heard argument around this in the hearing, that, you can literally complain about the president acting unconstitutionally or exceeding his powers, for many instances, because that's really what he does as a president. His role is to undertake a constitutional and perform his constitutional obligations. So it's easy to raise a complaint around the president not necessarily meeting his constitutional obligations. But it's not every complaint that will be entertained by the Constitutional Court at first instance. And the test for direct access to the Constitutional Court is still a robust one. So I think, if anything, that order by the court, and reasons will be given, it supports that particular premise that, when you do come to the Constitutional Court for any matter that engages the Constitutional Court's direct jurisdiction, it's got to be on all fours with the test for that. And the fact that you may say that the president has or has not acted in accordance with the Constitution does not necessarily in and of itself engage the Constitutional Court's urgent jurisdiction in this particular instance. So I think it's just reaffirmed that principle, and I do expect that when those reasons are finally made available, there'll be quite an emphasis around, how the Constitutional Court is accessed, and in particular, the fact that, you could complain every day about the president and his lack of, or at least failure to give effect to his constitutional duties. And if that is the case, you should usually start in the High Court unless it is of sufficient import and seriousness to come directly to the Constitutional Court.
So to that point, should the MKP decide to go and bring this application before a lower court, what do you believe that their chances of succeeding at that lower court may be?
Yeah, judging by the arguments that were exchanged a couple of days ago in the hearing, the MK party was pressed very hard on what elements or which parts of the Constitution were actually transgressed by the president. And I think it remained opaque through their answers and submissions. Or what exactly the complaint is. So, the matter will obviously be reheard again. There'll be fresh submissions, oral submissions, and fresh written submissions in a lower court. And who knows what the angle is taken around some of those elements where it was clear that the MK party's case has some shortcomings. So if those areas are improved, then maybe we may have a situation where the MK party's prospects of success are slightly more elevated. But as it stands, and if everything stays the same in the way they present their case through the lower courts, those prospects of success will probably be the same as what they are now, which is not very strong.
And then, all in all, the question somehow seems to remain unanswered, because part of what the MK party argued, Benedict, was that the president cannot place the minister on special leave. Well, they argue that there is no provision for that, and that therefore, I suppose they didn't quite say this, but if you were to push that further, saying that if ministers serve at the behest of the president, he can hire and fire as his presidential prerogative would allow. So is there a provision constitutionally for a minister to be placed on special leave whilst the president appoints an acting minister to that same portfolio?
No, Sakina, as far as I know, there is no provision that specifically empowers the president to act in that manner in the Constitution, But having said that, the president does have a broad prerogative around cabinet ministers, and I think the position of the president was also articulated during the hearing around that particular point. And it's not necessarily going to be the matter that really upon which the matter turns, because it's not necessarily the case that the power isn't there. It's really to what extent does the president's prerogative extend, which is the power that he has. And I think that's more the direct question, rather than because it's not there doesn't mean that the president doesn't have it. So I think it's likely to, those two areas will form the area of contestation. But I think insofar as the MK party is concerned, just relying on the lack of that provision in the Constitution, as opposed to potentially a building up of what the president can and cannot do in hard black and white terms as provided by the Constitution, would have been, that would have been the better angle to run this matter. And perhaps it may have led, or may lead, because who knows what they do with the matter going forward, to the outcome they need. But simply saying it's not there in the Constitution, I don't think is sufficient to say that the president wasn't empowered to actually conduct himself or act in this manner.
So, and I want to get your view on this, the placing of Minister Mchunu on special leave. So what is the long game that the president is playing here in terms of not just outright firing Senzo Mchunu, but placing him on special leave whilst there's this commission of inquiry that's established, the Judicial Commission of Inquiry into those allegations raised by the KwaZulu-Natal Provincial Commissioner of Police, and of course, at the same time, appointing an acting Minister of Police. That's meant to happen this morning, because what then happens at the end to Firoz Cachalia once the president has made up his mind? Does he then simply get fired or relegated again to go back to where he came from? What happens then?
Yes, I think with respect to the professor's position, it's slightly more simpler than Minister Mchunu's position, because the professor is acting, and when you're acting, it means that you're not there on a permanent basis, and when your period of acting comes to its termination, then you vacate your acting role. The placing of Minister Mchunu on special leave, I think, is the more curious decision, which is exactly why it prompted the MK party to go to court, because, the president was really faced with allegations that were made in a very public way, which indicated that there was, at least a prima facie evidence relating to Minister Mchunu's involvement in the allegations that Mr. Mkhwanazi put forward. Right. And that really raises an important question, because if it is found that Minister Mchunu is actually in the wrong, then you will end up with the situation that the president probably did not act correctly in this particular instance, because if that is what the facts establish, then he would have had exactly the information at that time that he placed Minister Mchunu on special leave to actually have made the decision to fire him. And I think this really illustrates potentially the weakness of the president in being able to make decisive decisions around elements which are serious, and you call them serious and grave, such as these. And the long game is probably that he doesn't have necessary, in as much as he feels empowered as a president, but maybe there are stakeholders around him, that he has to sort of discuss these with, and he doesn't necessarily have the full presidential prerogative that you'd expect a president to act decisively, as we all anticipated he would do in this particular instance.
We have a minute, Benedict, but I must ask you about the precedent-setting nature of this. So given what has happened and placing a minister on a leave, special leave, with, of course, full benefits, would this be an expectation from other ministers going forward until they are proven to be innocent of whatever it is that they may be charged with?
And, given the type of ministers and the problems, plaguing the ANC at the moment, I wouldn't be surprised if we have a situation like this again in the future, except it would be a misplaced expectation by that particular minister, because, it's very clear that the ministers serve at, the president's prerogative. So even if we have another situation and the president decides to take us, a stronger line, for instance, the DA deputy minister, that minister would then have to just accept the president's decision, and it would be foolish to really escalate something like that through the court process.
Well, thank you so much, Benedict Phiri. Always a pleasure. Legal analyst and managing director at LusPrudentia Specialist Counsel, talking to us about yesterday's Constitutional Court order dismissing former President Jacob Zuma and Umkhonto WeSizwe party's urgent application before the Constitutional Court, challenging President Cyril Ramaphosa's decision to place Minister of Police Senzo Mchunu on a special leave.